You're tuned in to Agriculture Today, and we start our Thursday show continuing to review ag law and tax developments in 2023. And to talk about it, we're once again joined by K-State and Washburn law professor Roger McEowen. Roger, thanks for joining us.
Well, thank you for having me, Shelby.
Talking about 4 developments from 2023, and the first one talking about the scope of the Dealer Trust Act. And what is the Dealer Trust?
Well, it was enacted in late 2020 as an amendment to the Packers and Stockyards Act. And, of course, the Packers and Stockyards Act applies to transactions involving livestock and poultry in interstate commerce that involves a covered packer or dealer or market agency or swine contractor or live poultry dealer. But the Packers and Stockyards Act basically applies to the larger operations. And there's always been an attempt, I shouldn't say always, but in recent years there have been attempts to modify the Packers and Stockyards Act to provide protection to unpaid cash sellers of livestock to the smaller packers or feeders and brokers and small processors. And that's what the Dealers Trust Act is. What it does is it puts unpaid cash sellers of livestock ahead of that buyer's prior perfected security interest holders. So it's a provision like the trust that exists for unpaid cash sellers of grain to a covered grain buyer. And that was the whole purpose of the law, is to provide protection to farmers and ranchers that sell covered products to these relatively smaller buyers.
And there was a case that made it to court in 2023 that deals with the Dealer Trust.
Yeah, that's right. We've got the first test case that is going to test the scope of what the Dealer Trust Act is in terms of what is included in that trust. And that's a big issue because if your buyer files bankruptcy and you are an unpaid cash seller, you're going to go to the back of the line. You're probably not a secured creditor. You didn't file a UCC Article 9 security agreement, and so you're not secured. And so if they file bankruptcy, the secured creditors, such as that buyer's lender, is going to get paid before you do. And there may not be anything left in the bankruptcy estate to pay you. And so what this does is it holds your funds. The idea is your funds that you're entitled to in a trust separate from the bankruptcy estate. And what the case involves is the issue of exactly what is the scope of the act in terms of what is going to be included in that trust that would be available for those unpaid cash sellers and what is in the bankruptcy estate of the bankrupt feed yard or processor, for example.
So planning to see actually what that scope is in 2024?
Yeah, and it's a big issue because there's a lot of money involved here. There's about $122 million in unpaid claims against 3 defunct cattle operations. And there's also a lender, a major ag lender, that says one of the feed yards sold about 78,000 head of cattle and didn't pay on the loan. And what these feed yards got into was a Ponzi scheme to the tune of about $175 million, a check-kiting scheme. And so this is the aftermath of that, and the courts are hopefully going to sort out who gets paid what, and we should know the scope of the Dealer Trust Act in 2024.
And Roger, another development in ag law and taxation from 2023, a case involving equity theft out of Minnesota.
Yeah, this is a case that went all the way to the U.S. Supreme Court and resulted in a unanimous opinion from the court in 2023. And you're right, it came out of the Minneapolis area, Hennepin County, and there was a homeowner in Hennepin County that failed to pay property taxes, and the county followed state law and ultimately sold the property at public auction to pay the taxes. Well, that's fine. However, the county then kept the entire sale proceeds and didn't give back to the homeowner the amount above the taxes that she was obligated to pay. So in other words, they didn't just keep the amount that they were entitled to for payment of late real estate taxes and fines and interest and those types of things. They kept the entire amount. And her argument was, well, I'm entitled to my equity in the property. You can't keep that. And the Supreme Court agreed. And it was unanimous. And this is an issue that some states have, and they're going to have to retool their statutes in light of the Supreme Court's opinion.
And another case really important from 2023, customer loyalty rewards and really creating maybe a tax issue for some companies.
Yeah, that's right. This is a big case involving a non-ag company, Hyatt Hotels Corporation. But many companies, including agribusinesses and retailers, they utilize these customer loyalty programs as a means of keeping and attracting customers. And we deal with this just about on a daily basis. There's so many of these programs out there. You go buy gas, and you're asked, do you have rewards? You go to a hardware store. You go to any type of ag country store, for example, to buy products for your farm. And they'll ask you, well, are you a rewards member? Well, yeah. Well, if so, then you can build up credit that will allow you to redeem those points. And once you get to a certain threshold, you might be able to buy an item from that retailer, or you can use them as a discount on a subsequent purchase. You might get a certain amount off per gallon of gas, for example. And sometimes they come in the mail to you and as a coupon, and you can redeem your reward points that way. Well, the question in Hyatt Hotels was whether the parent organization that has all of these associated hotels, and we can think of it also as an agribusiness that's got retail outlets, they create a fund in which the participating hotels, in this instance, contribute money, and they get reimbursed out of that fund when a customer redeems their reward points. Well, Hyatt Hotels, the parent corporation, is managing that fund, but they're not reporting the income in that fund. They're not reporting the income from the investments that they make based on the income in that fund, and they're not deducting any expenses when they pay amounts out of that fund to reimburse participating member hotels. And the IRS didn't like that, and the tax court agreed that they said, Hyatt, you maintain too much control over that fund that you're not able to claim that that is not included in income. It is. So that's a major, major case, and I think that has implications for a lot of retailers, including agribusiness retailers, that may not be doing this correctly from a tax standpoint.
So what are a few things that people need to think about to hopefully do it correctly?
Well, they have to watch how much control they exercise over the fund out of which the participating members are being reimbursed. And that was really the key to the case. The control that they had retained in this instance made the argument impossible for them to say that they were just a trustee of the fund. They were just kind of managing it, but they're not exercising control over it. They were. There is an exception out there known as the trust fund doctrine established in a case involving 7-Up back in 1950. But that didn't apply in this instance because of all of the control that the parent company had over that fund. So it's a good case in terms of laying down a marker for those that are giving tax advice to clients that offer these customer loyalty reward programs. And the retail businesses that offer these and participate in these will want to ensure that their program is structured in a way that fits within this trust fund doctrine, the exception under that for excluding program funds from gross income. So I think it's a big case on the tax side of things.
And Roger, one last thing for us to talk about today, basis of assets contained in an intentionally defective grantor trust. And what is an intentionally defective grantor trust, and why might someone want something that is defective?
It's an estate planning technique for a very unique type of clientele, usually the wealthier clientele, so a large farming and ranching operation with a lot of wealth. It's a good estate planning technique that we can use as a succession planning transition type device. And what it is it's an irrevocable trust that has language in it that makes sure that the individual grantor, the person creating the trust, pays any income tax on the property that's contained in the trust. So you might transfer farm or ranch land to an intentionally defective grantor trust or other types of property. And if that generates income, you're still going to pay the income tax on that, even though you've transferred the property away from you and have gotten it out of your estate at the time of death. And that's the idea here. So some would say, well, why would I want to do that? It's effective for estate tax purposes. It's defective for income tax purposes because even though I transfer all the property away and it's a separate tax entity, normally it's a separate tax entity, but here I still pay the tax on it. Well, the idea is that the grantor is from the wealthier generation. They have the money, and they're trying to move that property to the next generation. Well, let's not burden the next generation with the tax on it. I'll still pay the income tax on it so that farm or ranch land, that farm property that I've transferred away, continues to appreciate tax-free, in essence, in the hands of my beneficiaries. And so that's the whole idea behind it. The question that has been out there for a number of years, and the IRS finally answered it in 2023, was when that grantor dies, do the assets in that trust get a basis increase equal to fair market value at the date of the grantor's death? Do they get a stepped-up basis in the hands of the beneficiary? In other words, is the retained obligation to pay income tax on the income generated by the assets in the trust, even though I've transferred them away from me, is that enough to cause inclusion in my estate to get a basis step-up in the hands of my heirs?
And Roger, what did the IRS say?
Well, they had vacillated on this for about 15 years. They'd gone back and forth, but finally in 2023, they issued a revenue ruling, which is official policy of the IRS, saying that no, you do not get a basis increase in the hands of the beneficiaries of that trust and those assets that are in that trust. So we're going to have to think about this in terms of its implications for estate plans where we have created intentionally defective grantor trusts. We now know that there won't be a basis increase in the hands of the beneficiaries.
Where can people read more about these cases, Roger?
They can go to my website and access my blog from the homepage of my website. It's washburnlaw.edu/WALTR, or they can also find it on Ag Manager through the Department of Ag Econ.
That was K-State and Washburn Law Professor Roger McEowen. The resources that he mentioned will be linked in today's show notes on agtoday.net.